Today, we will be discussing a variety of concepts that you need to know and understand for your state's real estate licensing exam, along with a few easy acronyms that will help you remember them. Stay tuned to the end for a couple bonus memory tips that will help you with your math portion of your exam. Let's talk about fixtures. Don't overthink the term. Go down to one of these big box hardware stores. They have giant stores full of fixtures, things you can buy and bring home and add to your home. A fixture is personal property that has been so attached to land or a building that by law it becomes part of the real property. Examples would be lighting fixtures, kitchen cabinets, drapery. Almost any item that has been added as a permanent part of a building is considered a fixture. In determining whether an item is a fixture, and thus part of the real estate, courts use the following 5 basic tests, which can be remembered by the acronym MARIA. Method of attachment, adaption, relationship to the parties, intention, agreement. First, method of attachment or annexation. How permanent is the method of attachment? Can the item be removed without causing damage to the surrounding property, or can any damage caused by the removal be easily repaired? Adaption to the real estate. If an item is uniquely adapted to the property, or the property is custom designed to accommodate the item, it may be deemed real property whether the item is easily removable or not. Examples include a pool cover that goes with the pool on the property, or a set of keys to the front door. Both items can be removed, but are integral to the property. Relationship of the parties. Courts usually favor specific parties when disputes arise regarding the selling of real property and fixtures involved. It's commonly observed that if the negotiation regarding specific fixtures is between buyer and seller, the buyer likely has the favor. If it's between tenant and landlord, the tenant is likely to win. Intention. If the seller had the intention of making the item a permanent part of the house when it was initially installed, then the item can be considered a fixture. For instance, a built-in bookshelf, bushes, or a mailbox are examples of physical property that are installed by the owner with the intention to be fixed in place, whether it is ornamental or serves a purpose. Agreement between the parties. This may be the most important test in determining which existing fixtures remain with the property for sale or belong to the seller, and may override technical definitions of what counts as a fixture. What's the old saying? When in doubt, put it in writing. The general rule is that your purchase contract should specify as much as possible what comes with the real estate being sold. Next, we will discuss government powers, which can be remembered by the acronym PITT. Police powers, eminent domain, taxation, and escheat. Police powers. Every state has the power to enact legislation to preserve order, protect the public health and safety, and promote the general welfare of the citizens. That authority is called the state's police powers. Eminent domain is the right of the government to acquire privately owned real estate for public use. Taxation, a charge on real estate to raise funds to finance the operation of government facilities and services. And escheat. State law provides for ownership to transfer or escheat to the state when an owner dies and leaves no heirs, and there is no will or living trust instrument that directs how the real estate is to be distributed. Next on our list, we'll discuss joint tenancy. To create a joint tenancy, 4 elements or unities are needed, which can be remembered by our next acronym, PITT, like the college, P-I-T-T. Unity of possession, unity of interest, unity of time, and unity of title. Unity of possession. All joint tenants hold an undivided right to possession. You own a portion, but you have a right to possess the whole. Unity of interest. All joint tenants hold equal ownership interest. If there are 4 owners, each would own 25%. If there are 5 owners, each would own 20%. But the 2 more important ones are the unity of time and the unity of title. All joint tenants acquire their interest at the same time. The closing was Friday at 2 o'clock. All 4 of us buyers have to be there at the closing table together, right? This is the way owners take ownership interest in a property, by delivery and acceptance of the deed. So since we're all 4 buying this property together, we all need to be at the closing to accept the deed. Unity of time and unity of title. All joint tenants acquire their interest by the same document, one deed. The seller has one deed drawn up. This one deed names the 4 of us as buyers, and the 4 of us need to be at the closing together Friday at 2 o'clock to accept that one deed together. That's the unity of time and title. Next, let's talk about contracts. A contract can be described as valid, void, voidable, or unenforceable, depending on the circumstances. A valid contract meets all the essential elements that make it legally sufficient or enforceable and is legal in court. A void contract has no legal force or effect because it lacks some or all the essential elements of a contract. A contract that is void was never a legal contract. For the example, the use of forged names in a contract would make that contract void. A voidable contract appears on the surface to be valid, but it may be rescinded or disaffirmed by one or both parties based on some legal principle. The contract was not entered into by free and voluntary consent, or maybe one of the parties was under the influence. That would make the contract voidable. To remember the essential elements for a valid contract, remember the acronym CLOC without the K. C-L-O-C. C, consent. A contract must be entered into by consent as a free and voluntary act of each party. Each party must be able to make a prudent and knowledgeable decision without undue influence. A mistake, misrepresentation, fraud, undue influence, or duress would deprive a person of that ability. Legal purpose. The contract must have a legal reason for existence. Offer and acceptance. In a real estate sales transaction, the sales contract sets out the offer by the buyer that's accepted by the seller. And C, consideration. Consideration is something of legal value offered by one party and accepted by another as an inducement to perform or refrain from performing some act. Next, the fiduciary responsibilities of an agent. The agency agreement between a broker and client usually authorizes the broker to act on the principal's behalf. Under the common law of agency, an agent owes the principal the 6 duties of care, obedience, loyalty, disclosure, accounting, and confidentiality, which can be remembered by the acronym COLD AC. Care. Agents must exercise a reasonable degree of care while transacting the business entrusted to them by the principals, using their skill and knowledge on their principal's behalf. Obedience. The fiduciary relationship obligates an agent to act in good faith at all times, obeying the principal's lawful instructions in accordance with the contract. Loyalty. The duty of loyalty requires that the agent place the principal's interest above those of all others, including the agent's own self-interest. We sell homes for $50,000 and we sell homes for $500,000. There is a world of difference in commissions. However, the services we provide are the same. Disclosure. It is the agent's duty to keep the principal informed of all facts or information that might affect a transaction. The duty of disclosure includes relevant information or material facts that the agent knows, or in some cases, what the agent should have known. Accounting. The agent must be able to report the status of all funds received from or on behalf of the principal. Confidentiality. An agent may not disclose the principal's personal information, for example, the principal's financial information. Next, we will discuss the bundle of legal rights that go along with ownership of real property. Real property is defined as the interests, benefits, and rights that are automatically included by the ownership of real estate. In many states, the term real estate and real property are synonymous and are used to refer to both the physical property and the rights of ownership, while other states still make the distinction. Ownership rights of real property are described as a bundle of legal rights. The concept of a bundle of rights comes from Old English law. In the Middle Ages, a seller transferred property by giving the purchaser a handful of earth or a bundle of bound sticks from a tree on the property. After accepting the bundle, the purchaser became the owner of the tree from which the sticks came and the land to which the tree was attached. Because the rights of ownership, like the sticks, can be separated and individually transferred, the sticks became symbolic of those rights. And to explain that, the first legal right of ownership is the right of possession. If you own a home, you have the right to possess that home, obviously. But do you not also have the right to move out of that home and rent that home to a tenant? You have given up the right of possession without giving up the other rights of ownership. You've individually transferred that one right. Other rights include right to control the property within the framework of the law, right of enjoyment, to use the property in any legal manner, right of exclusion, to keep others from entering or using the property, and the right of disposition, to sell, will, transfer, or otherwise dispose of or encumber the property. These rights can be remembered by the acronym Deep C. Let's move on to value. To have value in the real estate market, that is, monetary worth based on desirability, a property must have the following characteristics, which can be remembered as DUST: demand, utility, scarcity, and transferability. Demand: the need or desire for possession or ownership, backed by the financial means to satisfy that need. Utility: the property's usefulness for its intended purposes. Scarcity: a finite supply. That makes sense, right? If there was an infinite supply of land, it would be worth a lot less. The fact that land is scarce gives land value. And transferability: the relative ease with which ownership rights are transferred from one person to another. Those acronyms definitely should help with remembering these important concepts. Here's a few other memory tips. Mortgagee versus Mortgagor. Which is which? Words ending in ER and OR apply to one doing the action. The buyer is mortgaging the property and is the mortgagor. An EE word describes one who receives the action. The lender receives the signed mortgage, accepts it, and holds it, and is the mortgagee. Here's another memory tip to help you remember. Mortgagee and lender both have two E's. Mortgagor and borrow both have two O's. How about an acronym to help remember the fair housing protected classes? Simply remember fresh corn, but without the vowels. Familial status, race, sex, handicap, color, religion, and national origin. Lastly, here are a couple of memory tips that will come in handy on the math portion of your exam. How many feet in an acre? Remember this: 4 old ladies driving 35 in a 60. How many feet in a mile? Remember, 5 tomatoes because it sounds like 5280. Thank you for watching. We hope you find our videos helpful when it comes time for taking and passing your state's real estate licensing exam. So please like, subscribe, and hit that bell below. That way you can be notified when we upload our next video. Thank you.